And I'm still alone. Hmm? Hi. Hi, let me quickly send Geoff another link. I think there were two links or he's joined. Yeah, so just a moment.
Yeah, there was something. I just saw something from Jeff, maybe. But this is the link that participants will follow.
Yes, yes. Thank you. Just a moment.
Yep.
Hi, Matthew. I think Professor Geoff is still trying to connect. So I will kindly request the participants to give us a few more minutes as we wait for others to join and as also we try to get Professor to connect. Thank you.
And with her.
Hi, Jeff. Nice to see
Yes,
you.
we have
Looks like
success.
you're in.
Yes. Took a while.
You appear as Maureen, though.
That couldn't care less who I'm known as. Just as long as we're here.
Yep, we're in the right place at the right time.
Yeah, well, possibly 2 minutes late on my part, but we'll get there.
Thank you, Professor Jeff and Professor Matthew. I think we can begin the webinar now. And I welcome us all to this webinar on legal tools for a changing climate. As we all know, climate has been impacting the world quite a bit, and the vulnerable are most affected, especially the refugees. And therefore, we thought of this webinar just to share knowledge and tools that can be used to try to protect those who are displaced as a result of climate change. And therefore, I want to start with introductions. And my name is Maureen Okoth from the Global Strategic Litigation Council. And I welcome Professor Jeff and subsequently Professor Matthew to introduce themselves. Thank you. We can't hear you, Professor.
How many years have I been using Zoom and I still can't unmute? This is a good start to the day. Right. It's my fault for starting late and I want to apologize. The links did not work. Maureen fixed it behind the scenes by sending me a direct link, which is why I appear as Maureen Okoth in the according to this. I'm Professor Jeff Gilbert. I'm Professor of International Human Rights and Humanitarian Law at the University of Essex. I'm Sergio Vieira de Mello Professor as well, which is a UNHCR title, and I'm a Senior Advisor on protection policy and legal advice to UNHCR. But most importantly for this purpose, as we'll see, I'm one of the co-authors of the Practical Toolkit, and that we'll come into later. Matthew, over to you.
Thanks, Jeff. I'm Matthew Scott. I lead the Human Rights and Environment thematic area at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund in Sweden. My main focus is on the varieties of climate and environmental human mobility. And in that capacity, I'm very happy to be part of the GSLC initiative on developing the climate mobility case database that we'll talk about in this session. Back over to you to kick us off.
Thank you so much. So we'll have two presentations, one from Professor Jeff and the other one from myself and Professor Matthew. And then after that, we'll have a Q&A session. However, if you have any questions, you can drop them also in the chat. However, we'll have a session for that. So now I want to introduce our first presenter, Professor Jeff, to take us through the toolkit. Thank you.
So I'm hoping you can hear me. And if you can't, good, yep, excellent. Right, so you can now see the presentation. It's a PowerPoint. It makes life easier, and this PowerPoint will be shared after we've done the presentation. So he says, let's hope this works. Right. What I'm planning to do in the next 30 minutes or so is introduce the Practical Toolkit, particularly the 5 key considerations that decision makers will be needing to deal with when climate or disaster impact in some way on cross-border displacement, and doing that in the context of human rights law. And we have some case law examples as ways to highlight how this works in practice. The object of our Practical Toolkit was to speak to those who actually advocate or are indeed the person who's being forcibly displaced, so that climate issues are just part of the overall decision. And I think from this next slide, you can see that climate-affected displacement and disaster-affected displacement are on the increase. This is from the Global Report on Internal Displacement. So it's only dealing with internally displaced persons. It's up by about 20 million on last year, We now have 65.8 million people who are displaced as a result of climate or disaster. 20 of those, sorry, we have 65.8 million people displaced internally, 20 million conflict and violence, and 45.8 by climate or disaster. What this, of course, doesn't indicate is where there are multiple causes and where the climate or the disaster also was affected by conflict and violence at the same time. And if you think of some of the situations around the world where there is currently a climate event or a disaster, such as, let's take it, East Africa, but there's also conflicts going on at the same time. So what this figure doesn't tell you is how many of the 45.8 million or the 20.1 million actually also had either conflict or climate disaster in parallel with what is seen to be the main cause of this internal displacement. And of course, this is internal displacement. It has nothing to say about those who are forced across borders, although some of these people will, in the future, possibly cross an international border as well. This is our practical toolkit. And I think what's important to get across here is that the cases involving cross-border displacement, where climate or disaster are present as well, are now affecting decision makers now. This is not something for the future. We talk sometimes about climate change and increased disasters as though there's something that we are thinking will be happening in the future. These displacements are current, and therefore the team, which included Professor Jane McAdam and Tamara Wood, both at University of New South Wales in Sydney, and Professor Kate Trastram and Felipe Navarro, who are at the Center for Gender and Refugee Studies at the University of California College of Law in San Francisco, with the great support of UNHCR as well, put together this toolkit. And what I will do later on in the process is provide the link in the chat to the toolkit, which is on RefWorld, so everybody can download it for free. So do not think, oh, where can I get this? Later in the chat, we'll have the link to the toolkit. So moving on to the content, Practical Toolkit. It's displacement in the context of climate change and disaster, because as with most forms of human mobility, displacement takes place in a multi-causal context. Climate and disaster are just two events in probably a range of factors that made people decide they had to move. Okay, so never ever think, oh, is this someone who's fleeing because of climate, or is this person fleeing because of disaster? They're fleeing because of multiple causes. And those multiple causes could engage international human rights law, international refugee law. Okay. We're going to look in this presentation at the 1951 Refugee Convention, its 67 protocol, obviously, the International Covenant on Civil and Political Rights, and the Convention Against Torture. The toolkit, though, also, for the first time, provides regional analysis across Africa, Asia, Europe, and the Americas. So at that level, we've tried to make certain that specific regions get the proper context and analysis for providing protection in situ. It's not just about what's the Human Rights Committee said, what's the Committee Against Torture said. This is looking in the context of Europe, European Court of Human Rights, Court of Justice of the European Union. In Africa, not just looking at national decisions, but also at the decisions of the African Commission and Court of Human and People's Rights as well. We are not intending in any way, shape, or form to extend the law. All we're looking at is how to analyse existing law and apply it to the context of climate or disaster. And in that regard, again, and I'll post this in the chat later, I have the link, one should have regard to UNHCR's 2020 legal considerations, because that underpins how one could use the 1951 Convention 67 Protocol to address people who've been displaced across borders in the context of a climate event or a disaster. Later on, we'll hear also from Matthew about the climate law database and how that provides guidance in this regard. I should point out that in the US, the Center for Gender and Refugee Studies has already provided a toolkit for US lawyers. In Australia, the Caldor Centre for International Refugee Law is putting together a similar toolkit for Australian lawyers. I think in the context of Europe and Africa, which are many more states, it's going to have to be taken on board by domestic lawyers, but it's going to be something that, because of the tools we've already produced, because of their accessibility, it will be possible to easily adapt so that national laws can be put in place. And there you go. We are trying as much as possible to just apply existing law for lawyers and practitioners. And we're supporting, therefore, the development of national level guidance. This is the table of contents of the Practical Toolkit, and we are going to be focusing on the key considerations, which is here, and there you go. Those 5 key considerations are the focus of my presentation this morning. As you can see, it's much bigger as a whole document. But what we want to do is look at these key considerations, because these are the ones that should affect every decision relating to forced displacement, whether there's a climate issue or no climate issue, because, as you will see when we get there, there are no specific rules for international protection in this regard. As you can see from the table of contents, having looked at the key considerations, we then move on international frameworks, regional frameworks. And these are all supported by case studies as well, so that you can see how this rolls out in practice. So what are the 5 key considerations? The first is, as you probably saw, no special rules apply. Okay, claims that have a climate or disaster element should be assessed in exactly the same way as all other protection claims. It's a systematic application of international refugee law, international human rights law, and there's no general proposition that people displaced in the context of climate change or disaster will or will not qualify for international protection. That's not the starting point. The starting point is, what's the international protection regime say? How do climate and disaster fit within that? Okay, so it's not about trying to create new law. It's not about special regimes. And you don't require, therefore, a specialized understanding of climate science. Okay. The most important thing, though, is to take into account the hazardscape. And you've got to consider the hazardscape as a whole. So in other words, it's not just about sort of what's just happened, has there been a climate event or a disaster, but how's that affecting the individual who's before you? Okay, it's a broader range of hazards that's going to affect the person's vulnerability. food insecurity, water scarcity, health risks. All these factors go towards whether the person in question needs international protection. So it's not just about saying, oh, what's just happened? It's how does that event affect the person's international protection? You've also got to take into account that climate and disaster affect individuals in different ways, and it's the usual age, gender, health, disability, different intersecting harms. It's going, would you send a child back or someone who is more elderly back to a disaster zone? You may take into account that age factor, which would not apply, let's say, to someone who is younger, in the sense of in the middle of their life. They may be able to cope, but an older person, a very young person, they couldn't cope. How does being a woman affect the context of return, given the nature of the effect of the disaster or the event? As always, though, human agency is relevant. Okay, some hazards occur naturally, but what happens afterwards may well have a human factor. How is the government responding? Is it treating all groups similarly? So it may be that the disaster or climate event affected everybody in much the same way, but the government subsequently provides aid or support only to particular groups. And therefore, that's an important factor in deciding whether or not the person is in need of international protection. And the other thing to take into account is the risk of harm over time. Okay, because climate events may have an immediate impact, but those impacts may then last and may get worse. Okay, and it's that affects how you make your decision, because as we all know, when someone is seeking international protection, the question is the risk of harm to them at the time the decision maker is making their decision. So it's not just about what were the factors that forced the person to flee, but what are the factors that are there now that may mean that the person cannot be sent back? So the risk of harm over time is something. Equally, just because it may be safe now, it may be clear that things are going to worsen. So again, the decision at the time of the person's application for international protection needs to look both at what's happening now and how things might play out going forward. This is the same as in every other decision dealing with international refugee law or international human rights law when people are forcibly displaced. So, turning to the law in place, it's the classic 1951 Refugee Convention definition. Article 1A2, a refugee is any person who, and we all know it, we can recite it together, probably in our sleep, we know this phrase so well. What's important is to think about how this test would play out with respect to climate event or disaster. So, well-founded fear of persecution. So what is persecution in this context? And this is why one has to take into account the hazardscape as a whole. The drought, for instance, could cause conflict between farmers and herders, pastoralists, okay, because of lack of access to water. So on that basis, the persecution isn't the drought itself, and an event that has occurred, could be natural, may not be natural, but it's how that affects the person being sent back. And generally, it requires human acts or omissions, and that's the human agency element we mentioned in the key considerations. Another example, it could be that climate activists are being targeted on the grounds of their political opinion. So when we're looking at why is the person seeking international protection, yet one takes into account the climate or disaster, but it's part of the hazard scape as a whole, key consideration 2. And there may well be further persecution arising as a result of existing inequalities and discrimination, which expose some people to more serious harm. Again, how does the state protect people in this context? Marginalized groups who are forced to live in a disaster-prone area or are denied access to assistance following a disaster, and where the government fails to adequately prevent or respond to climate change. Well-founded fear, there's got to be a real chance of persecution. It's a forward-looking test. And that takes us back to key consideration 5. Consider the risk of harm over time. So for slower onset, impacts, consider potential trajectory over time, as well as potential government action to reduce the risk. And the fact that the harm is experienced by an entire community or by a large group, may support the well-foundedness. There's got to be nexus to a connection to one of the convention grounds: race, religion, nationality, membership of a particular social group or political opinion. But some of the cases I've already mentioned indicate how this would work. Political opinion, climate activists may be targeted in the state. Race includes ethnicity, so different groups might be treated differently in the country. Particular social groups, how are women, children, or people who are elderly or in any other way have diversity issues, how are they being affected? And then finally, as we know, although it's not part of the 1951 Convention definition and has no role to play in Africa, because the African Convention does not include this element, what about an internal flight alternative? Is there another part of the country of nationality to which the person could go instead of their normal home? Turning to, and there you go, international human rights law, I suppose the starting point is the Human Rights Committee, which in general comment number 36 on the right to life has said, environmental degradation, climate change, and unsustainable development constitute some of the most pressing and serious threats to the ability of present and future generations to enjoy the right to life. So in that context, therefore, Article 6 of the International Covenant on Civil and Political Rights provides a direct reference. The leading case, of course, is Te Atota and against New Zealand before the Human Rights Committee. And that case, the committee considered whether the impacts of climate change in Kiribati threatened the author's right to life such that it should preclude his return. On the facts, the court did not support the claim, but acknowledged the potential application of states' non-reform obligations under Article 6 and 7. And the full quotation from Te Atota, paragraph 911, reads as follows: both sudden onset events such as intense storms and flooding and slow onset processes such as sea level rise, salinization and land degradation can propel cross-border movement of individuals seeking protection from climate change related harm. The committee is of the view that without robust national and international efforts, the effects of climate change in receiving states may expose individuals to a violation of their rights under Article 6 or 7 of the Covenant, thereby triggering non-refoulement. obligations of sending states. Furthermore, given that the risk of an entire country becoming submerged underwater is such an extreme risk, the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. And I think that quotation, which is there, is so important in understanding how claims going forward. Moving to two case law examples. One is from the United Kingdom, one is from New Zealand. You can see that in the UK case, this is the lack of access to food aid, shelter, and safe water. And the United Kingdom Asylum and Immigration Tribunal held that in the context of severe shortages and limited alternative option survival, discriminatory exclusion from access to food aid is capable of constituting persecution. Moving to AC Eritrea, the direct and indirect actions of the government of Eritrea meant that vulnerable elderly persons, okay, who were in this case excluded, the government contributed to the risk of harm, the human agency. And the fact that the applicants were elderly put them more at risk. So this again, looking at key consideration 3, climate change and disasters affect different people differently, and this is a factor that needs to be taken into account. I'm now moving to Africa. Because of my late arrival, Maureen and I did not have an opportunity to prepare, because Maureen and I were both going to speak to this. So I apologize, Maureen. I will speak and then I'll give you space to say what you want to say, but we haven't had a chance to prepare everybody, so I apologize. So this is a map, as you can see, of East Africa, and the definition in Africa, the extended definition in Africa under the 1969 Convention, talks about a refugee also including every person who owing to external aggression, occupation, foreign domination, or, and this is the important bit, events seriously disturbing public order in either part or whole of his country or her country, and that of course means that the internal flight alternative is not relevant, is compelled to leave the place of habitual residence in order to seek refuge in another place. Between 2011 and 2012, people fleeing the combined effects of drought, famine, and insecurity in Somalia were actually given refugee status as refugees in Kenya and Ethiopia. So this is not new in Africa. The idea that taking into account climate and disaster was going to be relevant. Can I just add that in the chat afterwards, I will include reference to 2 documents. One is written by Cleo Hansen-Lowry. It's on the Ref World website, and it's assessing serious disturbances to public order under the 1969 Convention, including in the context of disasters, environmental degradation, and the adverse effects of climate change, and also a paper in the International Journal of Refugee Law by Tamara Wood, who is a refugee in Africa, a principal framework for interpreting and applying Africa's expanded refugee definition. This comes from 2019 International Journal of Refugee Law. And I'll put both those links in the chat after we finish this presentation. Maureen, did you want to add anything at the moment?
Yes, Professor. I think just to add that there are African guiding principles on human rights of all migrants, refugees, and asylum seekers that specifically define climate change migrants as refugees in the context of the definition of the OAU Convention governing specific aspects of refugee problems in Africa. And also to add that the African Charter on Human and People's Rights, just like the other human rights, international human rights treaties, also provide pathways in which climate change migrants can be protected. Thank you.
Yeah, That's principle, I think, Maureen, you're referring to principle 2, paragraph 4 of the African Commission on Peoples and Human Rights held 2023 statement, that the term refugee may also include persons who are compelled to leave their country of nationality as a result of climate change that affects their fundamental rights, regardless of whether such effects seriously disturb public order. So in other words, the African Commission has gone even further than the 69 convention. Doesn't even have to be an event seriously affecting public order. The African Charter on Human and People's Rights provides that additional protection in the same way that the ICCPR does at the international level, complementary to the 51 convention. Did you want to add anything?
That was all, Professor. Thank you.
Okay, thank you. So turning to Europe, Europe's a mess. It always is, because we have both the Council of Europe and the European Union. And jurisdictionally, they're separate frameworks, but they overlap. And the European Union Qualification Directive recast of 2011, which will be replaced by a regulation in 2026 if everything goes according to plan, doesn't expand the definition of refugee status, unlike the approaches in Africa and America, but it does create subsidiary protection where there is a substantial risk of harm, which for this purpose covers the same ground as Articles 2 and 3, right to life and freedom from inhuman, degrading, or torture, inhuman or degrading treatment or punishment from the European Convention on Human Rights. The only thing to note for those who are practicing in Europe is that you can be excluded from subsidiary protection under the Qualification Directive. You can't be excluded from the European Convention on Human Rights. Subsidiary protection and human rights and the European Convention on Human Rights, I'm going to deal with as one, okay, because in this it saves time. And so far, the European Court of Human Rights has dealt with climate change and human rights only with respect to duties of member states to people in the member state, which isn't really relevant with respect to considering people who've had to flee as a result of climate change or disaster. Okay. The leading case being Verein Klimaatverandering, Schweiz and others against Switzerland in 2020, especially paragraphs 544 and following. It's not particularly relevant. What has been relevant in cases before the European Court of Human Rights, dealing with people displaced as a result of a climate event or disaster, are the so-called health cases, okay, where they provide a valuable analogue given the socioeconomic dimensions of both health-related claims and climate change. And the relevant cases include D in the United Kingdom, N in the United Kingdom, Sufi and Elmi, where treatment would, and what they held is where treatment would not be as good in the destination state as it would in Europe. That's not sufficient to find a violation of Articles 2 or 3. And the mere fact the government doesn't have the resources doesn't render it in breach of the Council of Europe member state to return them. But subsequent cases of Papashvili and Savran show some positive developments. But the problem is the entire approach is ignoring key consideration on human agency and responses. What you need to look at is not how is this person going to be affected, but are they being affected differently because of a human agency issue? Does the government in the state to which the person returned treat different groups differently, at which point discrimination arises? Budieva and others, and Russia, which is there listed, okay, has important factors. So Russia knew, okay, there were mudslides, okay, but it didn't do anything, okay, and the risk of harm resulted from the authorities' failure to take action to protect people against a known disaster risk. So that's the human agency. There's a known disaster, the government isn't doing anything, that's a risk. And that's what provides a useful analogy. Turning to my final slide, people will be happy to hear. This is from our Practical Toolkit. Please read it. But I'm going to turn to a national decision. It's an Italian decision, because the national courts have been more generous in their interpretations than the Court of Justice of the European Union or the European Court of Human Rights. The Tribunal of Milan found in a Bangladeshi case that severe flooding, erosion, and landslides in the applicant's place of origin, which had already resulted in the applicant being displaced from his home multiple times, generated a risk of serious violations of the applicant's rights to life, physical integrity, health, a healthy environment, food, and housing. It held that these risks amounted to inhuman and degrading treatment, contrary to Article 3 of the 1951 Convention, and that the applicant was disproportionately affected due to his belonging to a disadvantaged social class. In holding that the risks posed to the applicant by environmental factors constituted treatment, the tribunal found that the risks had been aggravated by the state's failure to implement effective environmental risk management policies or basic assistance programs for affected populations. And that, I think, speaks to how one looks at these cases, the 5 key considerations. Is there a human factor? What's the government doing? Are different people affected differently? Looking at key considerations like that helps show how the traditional international refugee law, international human rights law can provide international protection in the context of a climate event or a disaster. And I know it's not quite yet, but I'm going to say thank you. And it's not quite the questions now, but the question and answer will follow. And I will stop sharing and hand over to Matthew.
Thank you very much, Professor, for reminding us that the existing legal framework is able to offer protection to climate change migrants. And we move on to our second presentation, and I will share my screen. And before we proceed, I'd like to introduce the Council for those of us who are joining us for the first time. And the Council uses the power of the people and the power of the law to advance the rights of the people on the move. We unite and support a coalition of over 500 refugee and migrant-led organizations, NGOs, lawyers, advocates, and academic experts with strategic litigation and legal advocacy across the world. And we have regional networks. Currently, we have the regional network for Africa, Asia Pacific, and Latin America. And what these regional networks do is to develop strategies, legal strategies or advocacy strategies. We also offer technical expertise or support. We also offer amicus interventions, training and resources. And also we have community building and peer-to-peer learning. And the Council has 3 priority areas: climate displacement, detention and due process, and legal status and lawful stay. Currently, the climate mobility database falls under our thematic area, climate displacement. And I think as a result of series of workshops and consultations, there was a need for free public library of global litigation related to climate mobility or immobility that practitioners can use to create strategies, strengthen their arguments, and also enhance their impact in this area of law. And therefore, as a result of that, the Global Strategic Litigation Council, Earth Refuge, the Raoul Wallenberg Institute, and the Zolberg Institute are pleased to announce the official launch of our database. And probably we may ask, what is so unique about this? And one thing we note that worldwide, there's no one portal or one resource that collects or collates cases or precedents resulting from climate change. And therefore, this is the first time that we are having such a tool that can be used to protect climate change migrants. And also, as a result, we will also be running spotlight blogs. Apart from just the summaries of the cases on the database, we'll be running spotlight blogs on important pending cases. We realize that there are cases that are so important to the protection of climate change migrants across the world. Some have been determined, some not. So we'll be highlighting those. And also we'll be giving analysis from the database on emerging litigation precedents across times and regions. And also we'll be seeking to amplify the voices of those affected. Professor has just talked about agency, and we realize how agency is such an important factor in climate change protection. And therefore the Council will be amplifying the voices of those directly affected. And now I welcome Professor Matthew to take us through the database. Thank you.
Thanks, Maureen. I'm going to spend, I think, probably just about 10 minutes introducing the database, and I'll do it in two steps. The first, maybe Maureen, if you scroll up to where we just were, because I've got two slides just giving a bit of a snapshot of what's in the database. So we've got that first slide, emerging trends cross-border. Maybe it's a misnomer to call it, if you scroll up a bit more, Maureen, because all I can see is, yeah, there, that'll do. Emerging trends cross-border. I think it's maybe preliminary to say anything about emerging trends relating to the cases in the database. But what you can see on the slide is the countries whose jurisprudence is currently captured there. That includes Italy, France, Germany, Switzerland, Belgium, Norway, Sweden, the UK, Australia, New Zealand, and the USA. These, I would suggest, are kind of usual suspects for international refugee law. There's plenty to critique in the name of international refugee law when it's these usual suspects that are generating the jurisprudence. But this is what we've captured so far. It could well be that there are other jurisdictions where judicial or quasi-judicial actors are making legal decisions about eligibility for international protection, but we haven't captured them yet. And this is the first of probably many calls to action that I'll make in this short presentation. Those who are participating in this webinar are encouraged to draw our attention to other cases from other jurisdictions so that it really becomes a representative database from jurisprudence from around the world. What we can see in the cases that are captured on the database is a variety of circumstances in which people are seeking and sometimes getting recognized either as refugees or people entitled to international protection under international human rights law, as Jeff has introduced through the toolkit. Also protection under domestic provisions. So we have, some of you will be familiar with the French case of a Bangladeshi man who had serious asthma and established eligibility for a residence permit under the French national provision on health exceptions to expulsion orders. And that got a lot of press. What got less press was that subsequently the higher court ended up overturning that decision, which made it more aligned with other decisions also on the database, people from Mongolia, Mauritania, and I think also the Democratic Republic of Congo. People from each of those countries had pointed to adverse environmental conditions as a basis for being allowed to stay in France under that provision, and nobody in the end managed to secure it. So we're not just highlighting success stories here. We're also highlighting scenarios where people haven't established their eligibility. I think time won't permit me to talk through all of the different scenarios because I really want to introduce the database as well, and you can explore it yourself. But I do want to point to something that I think is also distinctive about the database, which is the internal displacement jurisprudence. So if you scroll up a little bit more, Maureen, I can just highlight the really wide variety of circumstances where people are seeking judicial or quasi-judicial remedies for displacement in the context of disasters and climate change. And displacement understood broadly to include things like relocation or failures of the state to facilitate relocation, forced eviction in the name of climate adaptation or even climate mitigation action. We've got failures of evacuation. So the whole panoply of movement dynamics that's captured under the phrase human mobility are reflected in these cases that we've got on the database. And again, I think I'll hold back on diving more into it and instead share my screen. If I think that means, Maureen, you end up stopping and I end up starting. And I think this will take me there. Although first you'll see my Zoom screen and then I can move here. Right, so finally, here is the database. And I say finally because I've had a preamble before sharing it, but also because this is the product of probably almost 2 years worth of work together with the partners that you can see on the screen: Earth Refuge, the Global Strategic Litigation Council, the Raoul Wallenberg Institute, where I'm sitting, the Zollberg Institute on Migration and Mobility, and two law firms, DLA Piper and Evershed Sutherland. We've all worked together to conceptualize and consolidate these cases. And we continue to work to build the database now that it has a physical form. And what I'm going to do in about 5 minutes is just make you familiar with some things which probably you can discover for yourself, but I've got a little bit to say, so I'll say it. First of all, as I said, this is probably now my second call to action. If you know of cases that are not captured here, click on this button and you'll be able to alert us by sharing a citation and maybe a link. That'll help us to grow this because the aim of the database is that it produces this accessible, free-to-use global resource for a variety of actors concerned with the protection of people who are displaced in the context of disasters and climate change, whether across international borders or within their own countries. And that's, in the first instance, civil society actors who are engaging in litigation, seeking accountability from relevant actors within their own countries, or litigation to secure international protection for people who are moving across borders. But it's got a broader reach because it's also relevant for judges themselves, and it would be great if at some point the International Association of Refugee and Migrant Law Judges gets a look at this database, but also even, and maybe we can get into this in the discussion, it even has relevance for actors like urban planners when we start looking at the disaster displacement stuff, internal displacement. So please provide more cases so that we can grow this database. And over time, and I said I wasn't going to provide an overview of trends as yet, because over time we're going to do that. We'll synthesize and consolidate and reflect and analyze so that those trends can become visible. And that makes it a useful tool because people will then be able to draw inspiration from successes and failures in their own jurisdictions, in their own regions, but as well across borders, kind of promoting not just what we hear as the transnational judicial dialogue, but even a transnational civil society dialogue, so that we're improving the way that cases are argued and decided in the spirit of a broad strategic litigation initiative. The methodology, which you can read, and I'll just say something very short about it, is a bit iterative. So we've drawn cases from existing sources, either that we've got as individual researchers. I've done a lot of research on jurisprudence myself, so I shared what I've got. And we've also gotten similar materials, for instance, from Kate Jastrom, who supported the development of the toolkit. So that's where maybe the start of the cases came from. But we've also now, thanks to the work of pro bono lawyers at DLA Piper and Evershed Sutherland, identified cases around the world by lawyers working within their own jurisdictions. So that's another resource that's been hugely valuable. Also for the internal cases, because they know their jurisdictions and how to find cases that might appear in the land tribunal or something where there isn't an easy to search database. So the more actors we have identifying cases in their countries, the better. Here's a bit of an introduction to what it's all about, but I think I've provided it. I'm not going to talk about this, which is just a visualization of the cases. Over time, you'll see more. You can filter it to show the type of mobility. It's kind of cool, but the real benefits, for the sake of time, are to be found in the substance of the cases themselves. So here you can say, and I think I'm just going to show one case, and I'll do an internal displacement case so I can say a couple of things about it. But before I go to that main page, this is the dashboard. You can even, and maybe this is how I'll get there, you can even search cases if you know a case. So you want to see if we've provided a summary of it or not. But before doing that, I want to say some other stuff about this. There's some more visualizations. This will grow as the database grows. Importantly, this number represents only a fraction of the cases that we've identified so far. So we've got 75 cases on the database, but in our case tracker, we've got 196, of which 75 are currently summarized in the form you can see in the database. And that includes internal and cross-border. The 75 are made up of 27 cases on internal displacement and 48 on cross-border displacement. The reason why we haven't got all of the summaries of the 196 cases online yet is because it takes a lot of time. And it takes so much time to produce really good synthesis summaries of cases that can be 100 pages long, that we've actually moved to a model that relies as much in the contemporary moment on artificial intelligence. We've got a whole AI team that has developed a bespoke GPT that reads the case and populates the fields that we've identified as being of interest, all the way down to relevant quotes from the case itself. That's been a bit tricky to get it to not hallucinate, and that's why we're still kind of in the process of making sure that it's doing the right job, but it's really close. And I'm going to show you now, just to say you can filter according to lots of different parameters. But I'm going to now show you the Guyo case from Kenya. And I recognize some in the audience are sitting in Kenya right now and may even know this case. This is a case that we got AI to summarize. And you can see, you can have a look at it yourself. You can click here and get the judgment and read it. All of our summaries have this feature where you can link directly to the judgment. Some of them, if they're in other languages, we have an AI translation of. It's also worth mentioning that if you speak Spanish, you can also click on the button here, and all of the description and the name of the court, all of the material summarizing the case is also in Spanish. Maybe soon enough we'll get it in other relevant languages, maybe French. It depends on what the cases are, I suppose. We've got a number of cases, interestingly, from Romania and Hungary. Maybe not enough to justify a whole translation bot, but maybe eventually some other languages will show up. Just now to introduce, because I promised 10 minutes and I think I'm not fulfilling that promise. So I won't say everything about this. We've grouped the cases into categories. We'll see if that's useful for different actors over time. But right now we've got 3 categories. Here's where the court directly considers the impact of disasters. So in this case, in the Guyot case, which is about the overflow of a dam in an extreme precipitation event that resulted in the displacement of the population in Garissa and other parts of the country. The court directly considered the impact of disasters there. And it's also a category 2 case because it's the applicants themselves specifically relied on the disaster as being relevant to their case. We have a third category of obiter dictum, which comes maybe more from the common law tradition, but it's cases where the court says something important about the way the law works in relation to disasters, but it's doing that in a situation that's not focused on disaster-related facts in a case. We've got a couple of those which really set the scene, especially in the international refugee law context, like Attorney General of Canada against Ward, and some others. Anyway, I digress. Here's what you get when you look at cases like this. You get a quick snapshot of what the case is about. You get the name of the court. You get the names of the parties. You get the decision in the judgment. Here, the applicants did not succeed in their claim. We have lessons generated. So based on what we find out about the case, what can we learn that might be relevant for future litigation? And this is sort of press release style. So here's what happened in the case, and here are the lessons. And then you can zoom in for more detail down in like the decision summary, where you actually get what the court said. You can also see the arguments presented by the different parties to the case. We've also captured some other stuff like relevant specific rights that are invoked, and some background to the case as well. The last thing I think I want to say is that this is a curated database. So personally, in the research I've done, I've identified over 400 cases that have something to do with human mobility, but some of them are just not very interesting. So it's not in the spirit of advancing a broad strategic litigation initiative to just dump everything into the database. Maybe over time for historical archival interest, we could do that, but we're really trying to get cases in the forefront of strategic litigation engagement that are relevant. So you don't have to sift through a bunch of cases that are less relevant to find the ones that are relevant. So that's why we've got 196 that we think are pretty important, and look forward to discussing it more with you and growing the database so that we can really learn from it. I think that's where I'll stop. I'm sorry that I couldn't do it faster.